Waivers? Don't you want to put the waivers on the record?
I don't know where you've been. We did that long ago. And the person that did it on the public defender side did it much better and smoother than you.
They're not saying it should be a permanent.
Huh? Oh, I don't want to hear from him all the time, but he did it there. I don't think that can happen consistent. Court does call the case, people versus Darnell Taylor.
Katie, mercy for the people.
Miss I can really. She
She's just.
is Janaza like gonna join us? Sat down, Miss Taylor came out. Everybody's not ready.
Here.
Yeah, you better put your head down.
Assistant Public Defender Chinazi Carey, I can really, Your Honor, on behalf of Mr. Darnell Taylor.
Fine.
Good morning.
Yeah, whatever. Your name, sir?
Darnell Taylor.
Your Honor, today is the date and time set for a preliminary examination in this matter. I'll let the people put their information on the record.
Yes, Your Honor, unfortunately, we are not able to proceed this morning. Have not.
And with that, Your Honor, we do move to dismiss.
People being unable to proceed, this case is dismissed. That's on defendant's motion.
Thank you so much, Your Honor.
Court does call the case for the people versus John Shelton.
Katie, mercy for the people.
Good morning, Rob J. Gill on behalf of Sean Shelton, who's approaching podium. Sean, state your name.
Sean Shelton.
Thank you.
Judge says the date for a preliminary exam.
And Your Honor, unfortunately, we are not able to proceed this morning. Again, witnesses have failed to appear.
Yes, this matter be dismissed, Judge.
People being unable to proceed, this case is dismissed. That is on the defendant's motion. Thank you.
Thanks, Judge. Good luck, Sean.
Oh, how do you do, madam? Magoo's the name.
Court does call the case, people versus Paul Walker.
Alex Warren Green on behalf of Mr. Walker. You state your name, Paul.
I surrender.
Yeah, Paul.
I'm not doing it anymore.
Mayor, today we are set this morning for a preliminary examination. There is a pending referral for criminal responsibility in this file. I do believe this has been previously adjourned to the defense request a couple of times. The people are requesting an adjournment to 225 for reasons we discussed in a chambers conference, to supplement the record to allow any result from that. One at this stage, although normally that is something that happens only at circuit court. Given the charges here, people are unsure whether or not the Center for Forensic Psychiatry will do that evaluation beforehand. So we are looking for that February 25th date.
Your Honor, I spoke to my client. At this time, we have no objection to the people's adjournment request. We stipulate to that agenda.
Preliminary examination in person, February 25th, 2025, 9 a.m. That's before me.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Bond continue.
I'll talk to you. Well,
Alice. What is she doing? Court calls case people versus Rayshawn Ellis.
Alex Warren Green on behalf of Mr. Ellis.
Raise your hand.
Thank you.
Your Honor, today's date and time for preliminary examination. The defense is ready to proceed.
The people are unable to proceed this morning. Witnesses have not appeared. I'm imagining the court will dismiss. Can we remand at least the count to the misdemeanor?
Defense would move to dismiss.
Court will dismiss count 1, count 2. Case is remanded to the 14 District Court.
He looks like a child.
Count 2. Already pled not guilty to that charge. I'll set pretrial on this matter for February 27, 2025, 11 a.m. before Judge Barr.
Thank you, Your Honor.
So we gotta.
Bond will continue. Thank you. You have the interpreter. Okay. When we're looking for you, we can't find you. Where are you going? Do you have another case in here?
I do not, Your Honor.
You don't?
I do.
Bye. No. I know. Take care. Court calls the case, People State of Michigan versus Marco Antonio Alaman Garcia.
Good morning, Your Honor. Marie Canada, Assistant Prosecuting Attorney on behalf of the people.
Good morning, Your Honor. Hannah Mackey requesting permission to practice under Michigan Court Rule 8.120 under Public Defender Norton Brown.
You have an interpreter present. May I have the interpreter sworn?
Raise your right hand. Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially using your best skill and judgment and to translate from English into Spanish and from Spanish into English in the matter now before the court, so help you God?
Yes.
Sure.
I'm ready.
What are we doing today?
Your Honor, this is the date and time set for our preliminary examination. This matter.
Your Honor, we would like to adjourn this matter. This morning, we had just found out that there was some discovery that we still need to look over, so we'd ask for a 1-week adjournment.
And Your Honor, to be clear, the discovery is a potential bond violation. We already knew that the defendant was calling victim's mom, for instance, which was the basis for the original violation. The court had revoked his own privileges. It appears that somehow the college may have continued. I'm not sure, we're looking into that. However, we finally had a Spanish speaking deputy look at, or I'm sorry, listen to digital calls. There are quite a few of them, but what he was able to gather was that he was telling other people to make sure the victim doesn't testify or testifies in a certain way. That I have asked the deputy to put that in a supplemental report.
But that information came through email just late yesterday, so while the report's done, I don't have it yet. I haven't been able to share it with the defense counsel. I did inform them this morning that we do have a potential violation. That deputy is here today, so if we needed to, and put any of that on the record, we could. However, it seems that the better option would be to give them some time, give the people time to review that report, but also defense time to review. So we would ask, well, we should schedule a bond violation hearing, because I believe that's what this is. So,
My next date would be 2 weeks out. Is there any objection to 2 weeks out?
No, Your Honor.
and for the record, Your Honor, we did make an offer to the defense previously. I was before knowledge of these violations, but we're gonna keep that offer open. We don't need to really discuss into his decision-making process regarding that, but that offer was to a child abuse fourth misdemeanor.
Got it. Okay, preliminary examination in this matter will be adjourned February 25th, 2025, 9 a.m. That's before me. I will also set a bond violation hearing at the same time.
Thank you, Your Honor.
Thank you, Your Honor.
Bond will continue.
Thank you. Your Honor, may I approach?
Yes, come on. Oh, both of you? What they teach these young kids these days. Okay, so how many?
I don't see him.
Four?
Has anyone spotted Magoo in the gallery there?
And that's Mr. Hall's case? Put that at the end. Okay, so I'm down to ones that we're holding on. I'm gonna take a brief break, but I'm just trying to figure out who, I'm not gonna ask who wants to go first, but what would be. Ms. Peroni, why are you staring at me like that?
I'm listening.
Never seen that before. What? I know. I actually today started out, said I'm gonna say nice things to everybody. It hasn't worked well, but my heart, it really is.
Your Honor, I would like to volunteer.
I want to say, I know I had issues, but I have good
Well, I
intentions.
still have a voice, yes, this is true.
Okay. Then which case is that?
Mr. Dowling.
Okay. Then we'll go with that one and then we'll figure out who's gonna be the next one. I'm gonna take a very brief recess and come back. We'll start with the Don Lee matter and do that. Mr. Hall,
Yes, sir.
you'll be ready on yours?
Oh, we're ready.
Can I ask a question?
Yes, Judge.
So I understand why Mr. Vincent has an assistant,
Yeah.
him.
Oh, I know so much more than that.
I was gonna say.
No, I'm just saying somebody help me here. I guess I put it the wrong way.
You think Mike and I came up with all our own good ideas, Judge?
So I'm trying to figure out like.
So he's not
So
there?
where's Vincent?
Oh, he's finished for the day.
Pardon?
He's finished for the day. He just ran an exam. He's gone, hopefully.
So did he get where he was supposed to go without you?
No.
Okay, all right.
You got the case dismissed. Now I'm over.
Oh, okay, so. you done- All right. Okay, I'm gonna take a brief break, come back.
Yeah. it doesn't matter.
And then we'll begin with the Don Lee matter. Who's on the other side of that?
Your Honor has already been a warning, Mr. Denham.
Okay. And they'll be ready to go. You'll be ready to go, sir?
Yes.
All right, so I'll come back out and we'll start that.
All rise.
Yeah.
Maybe seated.
Here's a little something for all you whiners who hate my music. Oh, yes. Oh, yes, you're going to get the whole thing.
There is no scandal at Law Talk Nation. You can only pay, get a notification. If you're lucky, it's a spicy fornication. It's another day on Law Talk with Mike. We got preacher on the dial, letting always make your chest smile. The pros say can't ever share a file. Defendants are always in denial. He was not driving, he's traveling. His reasons and facts are unraveling. It's another day of Law Talk with Mike. Courtroom is always popping off. You have a failure appear and you scoff. Judge Simpson is never going soft. Webster is always showing heart. We are heading into that soft six summer. Did you miss the line? That's a bummer. The soft six never gets smarter than dumber. He's not the man, he doesn't need a number. He was not driving, he's traveling. His reasons and facts are unraveling. It's another day of Law Talk with Mike. Courtroom is always popping off. You have a failure to appear and you scoff. Judge Simpson is never going soft. Webster is always showing heart. We are heading into. There is no scandal at Law Talk Nation. You can only pay, get a notification. If you're lucky, it's a. Judge Simpson will tell you that being a no. We just have one question: are you a hoe? Mr. Shots, oh Mrs. Shots, so where did you go? We have questions like on the weekends, do you work selling burritos? The Law Talk with my crew, we're here to laugh at you. We see you in court acting all tough. You solve issues and life must be so rough. Without getting into further details, there were drugs involved. I thought it was just glue that dissolved. Oh man, I gotta get it together because wow, that was messed up. And your honor, I have IBS and I'm bleeding inside and it's really been rough. The Law Talk with my crew, we're here to laugh at you. We see you in court acting all tough. Your soul's issues and life must be so rough. And now Kinky Kelly is shacked up in bed with the fruit bowl. Then the cat jumped on his wiener and started causing trouble. Love exciting and new. We are and always will be the Law Talk with my crew. The Law Talk with my crew. We see you in court acting all tough. Your soul's issues and life must be so rough. Without getting into further details, there were drugs involved. I thought I was smoking crack, but it was just glue that dissolved. I gotta get it together because wow, that was messed up. And your honor, I have IBS and I'm bleeding inside and it's really been rough. The law talk with my crew, here to laugh at you. We see you in court acting all tough. Judge Simpson will tell you that being a no. Need yourself one question, are you a hoe? Mrs. Shots, oh Mrs. Shots, oh where did you go? We have questions like on the weekends, do you work selling burritos? The law talk with my crew, we're here to laugh at you. We see you in court acting all tough. Your soul says citizen life must be so rough. Without getting into further details, there were drugs involved. I thought I was smoking crack, but it was just glue that dissolved. Oh man, I gotta get it together because wow, that was messed up. And your honor, I have IBS and I'm bleeding inside and it's really been rough. The law talk with my crew, here to laugh. On the highway claiming free, no power over me says my plea. I'm a sovereign in denial, gonna be here for a while. Justice lives and takes a seat. My arguments are obsolete. Just a fool in legal night, trying hard to win the fight. I'm just a sovereign idiot. My defense will fail spectacularly. To be guilty, that's not my style. Arguing laws that ain't worthwhile. I object to every word. No sense in what you've heard. Legal logic hit the ground. Round and round, lost and found. I'm just a sovereign idiot. My defense will fail spectacularly. To be guilty, that's not my style. Arguing laws that ain't worthwhile. I object to every word. No sense in what you've heard. Legal logic hit the ground. Round and round, lost and found. I'm just a sovereign idiot. My defense will fail spectacularly. To be guilty, it's not my style. Arguing laws that ain't worthwhile. In the courtroom standing proud, in a fog but being loud. Pointless battles in my head, stuck in rules I don't understand. In the courtroom standing proud, in a fog but being loud. Pointless battles in my head, stuck in rules I don't understand. In the courtroom standing proud, in a fog but being loud. Pointless battles in my head, stuck in rules I don't understand.
Attention, esteemed viewers. If you are hearing this message, it means that you are sadly witnessing a dark moment in the history of legal discourse. Yes, it's true. Law Talk with Mike is experiencing what we in the business call a plot hole size lull. This is, of course, due entirely to Mike's, let's say, ambitious approach to preparation. And by ambitious, I mean utterly devoid. Yes, the very fabric of our legal system, as represented by this live stream, has encountered a, shall we say, temporal anomaly. A glitch, a hiccup, a veritable vacuum of action. And who is to blame? Why none other host, Mike. So sit back, relax, maybe grab a snack. This musical interlude is just gonna be a thing. We'll get back to the legal stuff eventually, probably. So to fill the gaping void where insightful legal analysis should be, and due to a lack of any ability to keep your attention, Mike has in his infinite wisdom decided to subject you to this artistic expression. God help us all, please do not hold Mike accountable for this. Bless his heart, Mike didn't quite foresee these moments of dead air when he planned for this whole thing. He clearly has no idea what he's doing, so sit back, relax, and maybe grab a snack. This musical interlude is just gonna be a thing. We'll get back to the legal stuff eventually, probably.
Ma'am, are you a whore?
Fourteen District Court for County of Ocean, State of Michigan is back in session. The Honorable
You may be seated. Ms. Burton Harris, Ms. Tanner, could you approach on a separate matter?
Yes.
Number one, know what I'm saying? Number one, know what I'm saying? We are the Law Talk with my crew. Number one, know what I'm saying? Number one, know what I'm saying? Number one, know what I'm saying? Number one.
Yeah, court was muted, but that won't stop me from getting 100 comments saying, I couldn't hear court because you're playing songs.
Ma'am, are you a whore? You're not a whore? Not a whore? You're not a whore?
I never want to hear it again. Sweet Jesus.
You're not a whore? Not a whore? You're not a whore?
I never want to hear it again.
It gets worse.
There were drugs involved that were given to me that ended up being glue. Like, I smoked some glue and stuff. I thought I was smoking crack.
Let's go.
You didn't say the cat jumped on his knee, did you? Sit down and shut up. Shut up. Shut up. Cat jumped on his knee. Cat jumped on his knee. Shut up. Cat jumped on his knee. Cat jumped on his knee. Shut up. Cat jumped on his knee. Cat jumped on his knee. Shut up. Cat jumped on his knee. Cat jumped on his knee. Shut up.
Can you just let this go for once? For once? Once?
Okay, bad doing no. We'll get a whore.
With this level. 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 With this With his level. Mr. Sharps, Mr. Sharps, Mr. Sharps.
Everybody fucking dance.
You're not a whore? You're not a whore? I never want to hear it again. You're not a whore? You're not a whore? I never want to hear it again.
Now, if anybody thinks this is okay, I am in the wrong group.
Thank you. Oh, good Lord. We're taking testimony.
Are confusing at all, please let me know and I'll do my best to clarify. If you need a break during the questioning, please let us know, okay? Thank you. Pam, I'm going to ask you some questions about the reason you're here today. Before we do, can you tell us, do you know Adon Lee?
I know Don Lee. How I know him?
How do you know him? Yes, please.
I met him through a friend. He used to work for Kent Hall. That's how I met him.
Okay. And what's the nature of your relationship with him? You're engaged. And for how long were you in a romantic relationship with him?
On and off, well, about 5 years, not quite 5 years.
Okay. Do you see him in the courtroom today? Could you point him out, describe an item of clothing that he's wearing?
An orange shirt.
Thank you. Your Honor, may the record reflect the victim is identified as the defendant.
Without objection, record shows.
So like I said, we're going to talk about what happened that led to you being here today. Do you remember when this incident happened that we're going to be talking about?
13.
Of what year?
2020.
Thank you. We just have to be clear for the record. Thank you for that. And could you tell the court where it happened?
At the Days Inn, Carpenter.
Thank you. Thank you. And as far as you know, is that Pittsfield Township, state of Michigan, and Washington County?
Yes.
Thank you. So I want to start with why you were at the Days Inn. What brought you there that day?
We were going to move in with his cousin. So we had out a bunch of our stuff. And we went to the Days Inn. We were gonna go because we needed to go into the apartment after the landlord left because they didn't know that we were moving in.
Okay. And when you say you were going to move in with his cousin, who are you referring to?
His cousin named Lee, he lives in Chidester.
Okay. Are you referring to Mr. Don Lee's cousin?
No, I've never met him.
No, I'm sorry. When you say his cousin, is it Don's cousin? Okay, thank you. Thank you. So that's what brought you to the hotel.
Right.
On that date, in the hotel room or prior to getting there, had you used any substances? Had he? No, I'm sorry, on that date. Okay. Had Mr. Lee used any substances? Had Mr. Lee used any substances?
Yes.
And as you're sitting here today, are you sober and free of substances?
Tomorrow.
Congratulations. Could you share with the court what substances you or Mr. Lee had used?
Crack cocaine.
And did something happen on that date that led to police being called?
Yes, I was abused.
Okay. I'm going to ask you more about that, but we're going to start with who abused you.
Family.
So we're going to walk through and talk about what happened that day. Like I said, if you need a break, let us know, okay? Okay. Before we get to kind of any potential physical part, did you at any point have an argument with Mr. Lee?
When he got home, yes.
Okay. Could you tell the court a little bit about that, please?
He accused me of selling myself, and he told me that he saw me do it, and I never like done anything like that.
No.
It's just horrible, isn't it?
It's just ugly.
It's freaking terrible.
Okay. So
He said I would accuse me of lying, and so I mean, it kept going on. Um. And so I decided, well, maybe I should admit it to see. And I did that, and that's what he did lying. And then I get choked and smothered at the same time. I'm sorry.
No, it's okay.
I guess I must have passed out for a second. When I came to, I didn't realize where it was. You know, just for a second, and then everything was fine.
I'm going to ask you some more questions about that, and then we're going to move on to anything else that may have happened that day, okay? When you said Mr. Lee accused you of selling yourself, could you, I'm sorry?
Call it tricking.
Okay, and can you explain just for the record what that means?
That means I was a prostitute, accused me of being a prostitute, selling my body for money and for drugs.
Okay. And what was Mr. Lee's demeanor as he was accusing you of those things?
He was angry. Okay. He was angry with me because he himself believed it.
Okay. What was going through your head as he was accusing you of selling yourself?
I couldn't believe it, and I didn't know how to make him believe me. In 5 years, I never cheated on that. You know, when he does that stuff, he like hallucinates or whatever.
I'm sorry, when you say when he does that stuff, what do you mean?
When he smokes crack.
Okay, no, that's okay. I just have to clarify for the record, okay? Okay, and so you said that you told him no, you denied it, but then at some point you just said yes, that's something you've done. Why did you say yes?
I was hoping he would just stop accusing me. You know, I was scared, so I thought, I'm just gonna say yes.
Okay.
And he got even madder and said, you're lying. And then when I said, okay, I said, well, if you saw me, then you saw me. How could I be lying if you saw me?
You said you were scared. What were you scared of?
I was going to get hurt. I didn't do it. I could feel something.
You could feel what coming?
His anger mounting, and that I was going to get hurt.
Okay.
I was scared.
Okay. After you told him yes, and he said no, you're lying. What happened after that?
Again, I don't know time frame.
That's okay.
Anything. I just remember rolling on the bed, smothering me, and
okay.
And one time, he pushed me out, and my face was in the pillow. That was he in the bed, my head. My hair, he pulled some out. I was so scared.
Pam, are you okay, or do you need a break?
I couldn't understand. I couldn't understand why. Because why? How can you love somebody and do that to them?
So Pam, you said that, no, that's okay. That's okay. You said that he put your face in the pillow and pulled your hair. Did anything happen after that?
Well, we have oral sex.
Okay. Okay.
And they do that too. And we had oral sex plenty of times, you know, but not in anger, not like this.
Okay. So was his demeanor different?
No, he was still, he held my head down, and then after a few minutes, he said, "You're not focusing on me." And then he got mad because he said I wasn't focusing on him, I was focusing on some other guy. He used the N-word a lot.
I want to ask you some more questions about that. Okay. I want to go back to, you said that he was choking you and smothering you. When you were saying that he smothered you, and this is for the record, you were holding your hand, you're holding your hand over your mouth. Is that what he did?
Yes.
Okay. And your nose. So he was holding his hand over your mouth and your nose. Okay. Did that affect your breathing in any way?
Yeah, I passed out. Well, I don't know, not one time I passed out, but it was more than once. And she said that I was talking too loud and that the police were gonna come because I was talking too loud.
Okay. Okay. And then you also said he was choking you. Can you, no, it's okay. Can you describe to the court what he was doing to you? Okay, now you're grabbing your throat with your, for the record, with your hand grabbing your throat. Is that what he did? Okay. Did he squeeze?
Yes.
Okay. Did that affect your breathing in any way? Okay.
I could breathe after that, but then he let go.
Okay. Was he saying anything while he was strangling you?
The kill you. The wine.
Did you believe that he was going to kill you?
He told me he had guns in his backpack.
Did you believe him that he had guns?
Yes.
Was he saying anything else? Okay. What was going through your head when he was strangling you?
You know, we've been down this road before, but he's been using a lifetime. He is perfect. I'm so sorry.
It's okay. There's a reason the tissues are there, so we can give you a minute if you need one. Okay. It's okay. Okay, then you said that he pulled your hair and he pulled some hair out of your head.
It broke off.
Okay. And you testified that he put your face in the pillow. Okay.
And when he did that, he was pinching the back of my neck.
Okay, and that's what, for the record, that's what you're showing with your hand, that kind of pinching the back of your neck. Okay.
Right at the right spot.
Okay. And you said that he forced you to have oral sex. I know it's difficult, but I do need to ask you some questions about that, okay?
Okay.
Okay. Could you tell us, please, what part of your body he used? Okay. And what part of his body was involved? Okay. And can you tell the court how he did that? How did he force you to perform oral sex?
I had a back of my hair.
Okay.
Forced my head down onto his penis.
Okay.
And then it really got I didn't want it was in anger. I didn't want to do it in anger.
Okay. And no, it's okay. You don't need to apologize. It's okay. Was he wearing any clothing when he did this? Okay. So,
I believe, if I remember correctly, he put a t-shirt like over his head, but I'm not sure of that.
Okay.
But, you know, he was naked from the waist down.
Okay. Was there anything on his penis or was it bare skin?
No.
Okay. No, as in bare skin or?
Oh, yeah, no.
Sorry, I asked a weird question.
One question there.
Right, you're right. Thank you for telling me. What was he wearing anything on his penis?
No.
Okay, was it bare skin?
Yes.
Okay. Do you remember if his penis was erect or not?
No, it was not.
Okay. Not at that time? At some point during this incident, was it? Okay. Did he ejaculate?
Yeah.
Okay. Previous to, I'm sorry, give me 1 second. Was he saying anything during, while he was putting your mouth on his penis?
No, only that I wasn't focusing on him, that I was focusing on somebody else.
Thank you.
Who told me, let me up.
You said that he had mentioned that he had guns. Did you ever see those guns? Did you,
I've never seen a weapon.
did he tell you about any other weapon he had, or did you see any other weapon?
Well, he had a crossbow, I knew about that, but he didn't.
Okay. What did the crossbow look like? Do you remember?
Arrow, the arrow was either silver or white.
Okay. When he kind of pulled you by the neck and forced you to perform oral sex on him, where were you positioned, or how were you positioned?
He was in the blue chair, and I was on my stomach facing him on the bed.
Okay. And where was the blue chair in relation to the bed?
It was right next to it. He was the chair was right here.
Okay, thank you. So they were touching, you're kind of motioning with your hands that the chair was either very close to or touching the bed. Okay, thank you. During all of this, during this assault, did he touch or grab any other parts of your body? Did he hit or harm you in any other way, on any other part of your body?
Pardon me?
Did he hit or hurt you in any other part of your body?
I know he got me in the face, but.
Okay.
That's all.
Would it refresh your recollection to look at the statement you gave to police? Your Honor, if I may approach with, well, initially just page 6 out of 11 of the report. There should only be one, but for the record, 25-7 to 8. I'm going to show the page to defense counsel before I approach. Yeah.
Okay.
Got it?
Yes, you may.
Thank you.
That's okay. What I want you to do is look through that, don't read it out loud, okay? Look through it, when you read through it, then just look up at us so we know you're done. Okay?
I don't, slapping me in the face.
Okay, hold on. First, I have to ask you. Nope, you're okay. That's my job. Don't worry about it. So first, I need to ask you, did that help refresh your memory? Okay, now if I can I approach your Honor to retrieve that?
Yes.
Thank you. Okay, now, do you remember him doing anything to any other part of your body?
Slapped me in the face multiple times.
Thank you.
On and off, personal old sex. Then one time, this is when he told me that he had an erection this time, my mouth, then he pulled out and said that whoever I've been sucking must have taught me to suck me.
Okay. Do you remember telling police officers that he also that he punched you in the head?
Yes. Punched me in the head. And he was so good. I just break down. And he kept saying that I was talking too loud. So he would put a hand over my mouth.
Pam, do you remember parts of your body that would have been in pain during this incident or after?
My head, my neck. Oh. My elbow was, I don't know what happened, my elbow. My head, most of it was just my head. My neck, would you know that I have to have surgery?
You've had surgery or you,
No, I have.
oh, you need surgery? Okay. And he was aware of that?
Oh, yeah.
Pam, do you remember vomiting or urinating or defecating? Vomiting?
Yes.
Could you tell the court about that? When did that happen, if you remember?
Okay, and Robert. I apologize. You need this.
You apologize? Is that what you're saying? Why did you apologize? Pam?
After I threw up, I said, I'm sorry.
And did he say anything to you? I'm sorry, what was that?
He said I liked it.
That he liked it?
But he also told me, he also told me that my pussy was old and shriveled.
Pam, I'm gonna ask you some more questions about your injuries, okay? Your Honor, if I may approach with what is marked as People's Proposed Exhibit number 1.
Okay.
Thank you. Oh, I was talking to the judge here, okay.
Yeah, you can-
For the record, I'm showing the defense counsel that he has it as part of the discovery as well. Okay. And I'm gonna ask you some questions, okay? Can you tell the court if you recognize what that is?
Yes.
And can you tell the court what that is? Okay. And is that a fair and accurate depiction of the way your elbow and arm looked after the incident on January 13th, 2025? Thank you. Your Honor,
Object to relevance.
Hold on one moment. Your objection is to what?
I object to the relevance of her elbow injury.
well, you're,
It's needed overruled.
okay, thank you. Wasn't sure if I needed to. Oh, I'm sorry, Your Honor, can I publish that to Your Honor?
Yes.
He did not make your car those injuries.
Oh, these are not, no, okay, then. No,
All right.
we're not gonna move to admit those.
You know, I fell when we were walking back to the room. I fell because I had bad leg and then I read it on my cousin. Yep.
Okay. Thank you. Thank you, Pam, for clarifying that. I'm going to approach with what's been marked as People's Proposed Exhibit number 2. And I'm showing that to defense counsel before approaching.
Okay. No objection to that.
Okay. Your Honor, may I approach?
You may.
Pam, I've handed you people's proposed exhibit number 2. Can you tell the court if you recognize what that is?
Possible.
And is that the crossbow that Mr. Lee had on January 13th of 2025? That's a fair and accurate depiction of the way that crossbow looked on that date? Thank you. Your Honor, I would move to admit people's proposed exhibit number 2, and if I may publish it to the court.
Any objection?
Your
Or
Honor,
why?
I don't think the crossbow is relevant either. She told the police she wasn't threatened with a weapon. So what's the relevance of that picture?
But I just heard her testimony regarding the actions of Mr. Lee.
Thank you, Your Honor.
Thank you, Your Honor.
Objections overruled. Exhibit number 2 is admitted.
May I publish it to you? Your Honor?
Yes.
Thank you. May I have a moment, Your Honor? Nothing further at this point, Your Honor.
All
Thank
right.
you, Pam.
Cross-examine.
Good morning, Ms. Valdega. Did I say it right? Okay, Pam? Pam, my name is Ben Denowith. I'm a lawyer for Don, and I'm gonna ask you some questions. If you don't understand my questions, you can tell me, ask in a different way. If I don't talk loud enough, you can say speak up. Okay? So did you get to the Days Inn on the Friday before this incident? Okay, and this was on a Monday, so you're there about 4 days? Okay. During those 4 days, how many times did you smoke crack?
A lot.
Like more than 10 a day?
I don't know. I actually don't know.
Okay.
Sorry.
Would it be fair to say as much as possible?
Your Honor, objection, acid answered. She's already testified twice that she doesn't know.
Okay,
Sustained.
Thank you.
thank you. And during that time at the hotel, you fell down at least once and injured yourself. Is that correct?
I need.
Okay. Did you injure your elbow at some point too?
No, I already said that he did not do those pictures, he did not do that.
Okay. Did you only fell down once then in your stay at the Days Inn?
Down outside,
Right.
that's where I got the elbow, and the elbow.
Okay.
It was in the parking lot, it was icy, I fell down, he helped me up. Okay, he didn't, and I told you, he did not cause a little.
All right. And
He practically carried me.
and you told the prosecutor about being strangled and suffocated. You remember that a couple minutes ago?
Yeah,
Do you know specifically what day that was on?
the 13th,
So that would have been in the morning?
he got home at 2:30 in the morning, I believe. And so, yeah,
Okay,
yeah, because, yeah.
so was that all around 2:30 in the morning?
That's when we got back, I believe.
And when he got back is when he strangled you and suffocated you? Okay. And then was there a little bit of a break before the topic of sex came up?
You know, I don't know the answers like that. I told you I was hot. I'm not denying it, okay? When he made me a hit, I spoke it.
Okay. And that affects your memory, is that correct?
I guess I don't remember what. Ask me again, please.
Well, is it true that your memory is impaired regardless of if it's from cocaine or otherwise?
You and I, something to check is much of the way it's phrased. She's not a medical expert.
Sustained. You need to rephrase that
Okay.
question. It was compound, first of all, but also it assumed facts, not in evidence. Go ahead.
I'm sorry, Your Honor.
It assumed facts, not in evidence.
Okay.
Why would I lie about them?
No, ma'am, hold on. Just, no, you're okay. You're okay. No, it's all right. It's all right. Just wait for the question and then answer, okay? All right. Go ahead.
Okay, so is it fair to say you're not able to tell us if there was a time period or how long that time period would have been between the strangulation and suffocation and the oral sex that you described to the prosecutor?
No.
Okay. And you remember calling the police, right?
Yes.
Was that in the afternoon?
No.
It was in the morning too? Okay.
We have a hotel.
And you told the police to come, right? And then did you at one point tell the police that they didn't have to come?
Yes.
And
Officer, never mind, you know that. So. I was scared.
could you repeat that? You were just mumbling a bit.
I told, when I called 911, I told the officer, never mind, you don't need to come, I'm all right.
Okay. And then did you say something about you doing further things after that?
Pardon me?
Did you do anything after you called 911? Did you tell us about that?
I don't know what you mean, what did I do, what?
Well, when you were originally answering my question, it sounded like you said quite a bit more than you just told us.
Yeah, no, I'm sorry. Can we ask defense counsel to clarify? Because quite frankly, I'm a little confused too. Just ask her a direct question, maybe.
I would agree, because I'm not sure what you're referring to. You said you couldn't hear her,
Yes.
okay? But then just ask her a question and have her answer, I guess is my point.
All right. So Pam, you told the police that they did not need to come. Is that correct?
Yes,
And why did you tell the police that?
because I was scared.
All right. Was Mr. Lee still there when you told the police that?
Yes.
Okay. And did he leave the room?
Not till the officer showed up. Oh, no, the hotel manager, Mason Lee. Had told me that I had 20 minutes to get to our stuff packed and to get out of there.
All right. And was
What I called that was that they showed up.
after the hotel manager said that is when you called 911?
Yes.
Okay. Did you have any intent to call 911 before you were getting kicked out of the hotel?
I told you I called before I was getting kicked out of the hotel.
Right.
I told them never mind. Okay, because I didn't want to go through this. Okay, sorry.
Um,
Can we take a look? Is that-
Counsel,
Your Honor,
hold on one moment, Stan. Are you requesting a recess, counsel?
Can we take a 5-minute recess?
I didn't ask that. Are you requesting it? Because I'm not going to take it from the defendant. Are you requesting it? And then I'll make my decision.
Yes, I am requesting it.
Ms. Tanner, response.
I would rather just go through, we're almost done. I think this is a disruption, Your Honor, to a very sensitive part of this, and it's coming from the defendant, even though I understand that it's counsel's request. This is an attempt to stop where this is going, quite frankly.
I mean, I think it's an attempt to confer with my client and see what questions he thinks are important.
That can be done at the table. Is there a reason why I need to take a recess?
Oh,
I didn't ask you, counsel.
Well, Your Honor, I feel like he has quite a bit of things he wants to tell me and that they may not be able to be conveyed right here at the table.
It didn't even look like there was an attempt to, because Mr. Lee started that, and give it a shot at the table, because I'm not inclined to take a recess. Counsel, you may want to push down the microphone so that your conversation isn't overheard. Okay. All right. Ma'am, ma'am? Hello? Just sit and relax for a minute, okay? You're okay. We're gonna get you some water, okay? All right. You're welcome.
You know, we'll be back here, so.
His case hasn't been called.
Yeah, I have some questions. Um, During the strangulation,
That's what I was told.
did you use drugs with Mr. Lee?
Not during.
Okay, that was after, correct? Before and after, okay. And during the sexual assault, did you use drugs with Mr. Lee?
Not at that moment.
Okay. Did you receive any injuries from Mr. Lee striking you in the head?
I had bruises.
Okay.
They're gone now.
And you believe he struck you with a closed fist?
Yeah.
And did you see his fist?
No, I didn't see it going no.
Okay, so you weren't able to observe if his hand was open or closed? criminal history. Did you consume anything other than cocaine that may have affected your recollection?
I remember everything. Yes, I did. I had rum and coke.
Okay, how much?
No, the bottle was left there. It wasn't empty. But he had some of that too.
Were you on any prescription medicine at the time?
Yeah,
Did any of those prescription medicines say not to mix with alcohol?
I have no idea.
Do you know the names of the prescriptions you were taking at the time? Can you tell us?
Gabapentin,
Okay,
Goose bar, Lycopene, amlodipine, Prozac, bupropion, Wellbutrin. I mean, other, with an and cholesterol, but I didn't take them.
you did not take them that day.
No,
None of these medicines?
no, no, I would take them. But I did not take them like the day previous, yeah.
Okay.
I guess I don't remember taking that long.
So, do you remember going to the hospital?
Yeah,
And do you remember talking to a nurse?
yeah.
And they examined you at that hospital, correct? Did you tell the nurse that you injured your elbow as a result of something Mr. Lee did?
No.
Okay. Did you tell the nurse that you had bruises on your arm from Mr. Lee pulling on you?
Yes, I have.
Okay,
Part of that one,
but you did not state that injured your elbow.
no, I felt.
Your Honor, I'm gonna ask the court to instruct the defendant not to speak on the record. We can approach with his counsel. This is not the time for him to speak up the way he is. This is an attempt at stopping this witness's testimony. His previous attempts apparently have not been successful, and now he's trying to stop something that's very damaging to him. I would ask the court to instruct him not to do so further, and I'd happily approach with counsel if we need to.
I would respectfully say that's definitely not what's happening, but I agree with everything else.
You agree with everything, what?
I mean, I agree that the client should not be asking questions.
Have you instructed him not to do so?
I have advised him,
Mr. Lee, then I'll just do it. If you haven't, you won't be asking questions or anything along those lines. Counsel, what is he talking about a conflict of interest?
Your Honor, this is the first I hear about it, so I have absolutely no idea.
Can we
Okay.
approach? I could explain that.
Might be a good idea.
May I approach?
Well, it's getting a little dicey now. I mean, this is a horrible, horrible hearing that I did not intend to stream. I just wanted to see Magoo. But here we are. I don't understand. How is he asking questions? We're in it now. You know, I've got no complaints. This is a fun thing to do. I love streaming. But boy, you have rough days like this. I was doing a little quickie this morning in the chat. They say, "Hey, Magoo's are there." I'm like, "Oh, that's fun. I'll go do it." He said at 10 o'clock. And here we are, or 9 o'clock. It was 9 o'clock. Here we are 2 hours later. It's kind of like Eric Martin. That took all day to get to Eric Martin. But, you know, I like live streaming them in real time because it's just more fun because it's happening, you know? It's that simple. But if you don't do it from the beginning, then it'll happen before you know it. And if you start at the beginning, then they'll put them at the end of the call, and you'll have to deal with this hearing in the interim. All right, maybe we'll get a soft sit. Let me see what I can do here.
Counsel, do you have any other questions of this witness?
No further questions.
All right, any redirect?
Just brief follow-up, Your Honor.
Yes, go ahead.
Thank you. Pam, thank you for your patience. Pam, in response to defense counsel's question about why you told police not to come, never mind, something to that effect, you said it was because you were scared. Could you please tell the court what you were scared of?
Didn't want the police to take him away.
And why is that?
I love him.
How does it feel being here today?
It's horrible. It's horrible to think of. And it's crazy. This probably doesn't matter, but I've never loved anybody like that. And I just couldn't understand how he could hurt me like that. And when he is out with his friends, he did it her family. I tell him her.
So Pam, I'm gonna, one last thing and then I'm all done, okay?
Okay.
I said one last thing and then I'm all done, okay? Are you doing okay?
Yes.
Okay. Your Honor, if I may approach with people's proposed exhibit, I believe we're at 3.
3.
And I'll show it to defense counsel before approaching.
Let's go.
No, of your questioning? No, you asked her about the arm, so it's not.
But no
I'm just showing
objection.
you, I'm gonna approach.
No objection.
Very good.
And I'm handing you a Finmark's people's proposed exhibit number 3. I want you just to take a look at that. Could you please tell the court if you recognize what that is?
The bruises
Okay, where are the bruises?
on my arm,
Okay,
here, down here,
okay, and
down here.
and for the record, you're showing multiple places on both your arms.
Yes.
Is that sorry, you're leaning it against the microphone, which is, you're okay. I just want to make sure that, I know, it's okay. We want to make sure that we can hear you, and hear me since I'm struggling with the voice today. Can you tell the court if that's a fair and accurate depiction of the way your arms looked on January 13th of 2025?
Yes.
And are those from something that Mr. Lee did to you on that date?
Yeah.
Okay. Your Honor, I would move to admit people's proposed exhibit number 3, and if I may publish it to the court.
Any objection or voir dire?
No.
Exhibit 3 is admitted.
May I approach, Your Honor?
Yes.
Thank you. No further questions, Your Honor.
All right.
No recalls.
All right, ma'am. Ma'am, you're all set. You can step down. You're more than welcome.
And Your Honor, may she be officially excused?
Any objection to excusing this witness?
No.
All right, yes, she can be excused. Any witnesses for the defense?
No witnesses for the defense.
Motion.
I would motion to find out on the first degree, count 2, assault with to degrade bodily harm less than murder or by strangulation. So it's count 3, domestic violence, third offense.
Response.
Your Honor, the defense objects to the bind over on count 1. The witness was very unsure of the timeline, and the underlying offense that makes this a CSC1 instead of a CSC3, the strangulation, she just wasn't sure enough of the timeline to say that that was at the same time as the CSC. So we'd ask the court to reduce that to a CSC3 because the testimony did not support the idea that the CSC was committed at the same time.
What testimony were
Assault
you
by
listening to?
strangulation. That would,
I don't want that counsel no more. This is not.
Mr. Lee? Go ahead with your argument.
Your Honor, I'd also indicate the witness's memory was not reliable whatsoever. She stated multiple times that she used drugs and alcohol. Her memory seemed shaky. She didn't match up the times. I don't think she's a reliable witness, so the defense would ask the court not to bind over on counts 2 and 3 either. Thank you.
You may if you want. I don't necessarily need it, but go ahead.
Your Honor, just for the record. This witness was very honest about her partaking in drugs and alcohol. That despite that, she seems to have a lot of detail as to what happened, how it happened, and who did it. Quite frankly, and not that this is necessary, but for the record and for the benefit of counsel and apparently defendant, Michigan Criminal Jury Instruction 3.10, time and place, venue, and cases, we do not need to prove beyond a reasonable doubt, specifically the time something happened. Even with that, that we're not even at that stage, but just for their benefit moving forward, that is not an element of any of the offense, specifically criminal sexual conduct first degree, which is what counsel seems to have a problem with. Your Honor, we had plenty of testimony about the oral penetration that was forced on this victim. We had plenty of testimony about the multiple assaults. We had testimony about the smothering and the strangulation, not just one. It was one, but we heard about several. So Your Honor, there's more than enough evidence to bind over at this stage.
Anything else?
Then she's got a time period of hours and she can't say they're at the same time. So it doesn't have to be beyond a reasonable doubt. It's probable cause. So
Which is a much lower standard.
Sorry.
Which is a much lower standard. All right, based upon the testimony, the court does believe, and actually, one wants to get to credibility. I found this witness to be exceedingly credible. She said when things weren't the way that would have been, say, beneficial or harmful to the defendant, she said what she said. This court believes that she was extremely truthful in terms of what had occurred on that date. Specifically, the court does believe that people have set out the requisite elements regarding a CSC 1 in this case, as well as with count 2, the assault with intent to murder, the choking and her losing consciousness, as well as the court will take judicial notice of defendant's previous domestic violence convictions in the 14th B District Court. Not that I necessarily need them, but I think it should be clear for the record. In the 14th B District Court back in 2003, I think it was. And then also just located. And also in 2019 in the 14A2 District Court. So that nobody gets into that argument, the court would find that the people have indeed then sustained their burden and would find that the defendant should be bound over to stand trial on all charges. So defendants bound over to circuit court on counts 1, 2, and 3. How do you what?
I don't want their service, I want to promote. From here, I respect you.
Then you're gonna have to file a motion, and at some point you can file that before Judge Cookie, because I'm not gonna entertain it.
Okay, so you charge.
We'd like a formal reading and stand mute.
You're waiving formal reading?
No, we
Want a formal reading?
Yes.
I could have. That's fine. He's entitled to it. Let's just do it.
Oh, sweet Jesus.
Mr. Lee, you are before the court on an information that alleges that on or about January 13, 2025, location at 2380 Carpenter Road, apartment or number 116 in Pittsfield Township, Washington County, State of Michigan. Count 1 alleges that on that date and at that time that you did commit the offense of criminal sexual conduct in the first degree. Alleged multiple bureaus, that you did engage in sexual penetration, that being oral, penile, with a Pamela Valdega under following circumstances. That was during the commission of a felony, that being the felony of assault by strangulation contrary to Michigan statute. Do you understand the nature of that charge, sir? There is also a notice that this is a tier 3 offense under the Sexual Offender Registration Act, unless the court finds that the victim was between the ages of 13 and 15 inclusive, consented to the conduct, and the defendant was not more than 4 years older, then you would be required to register as a sex offender under statute. You understand that, sir?
What's the charge here? Getting to another charge.
You don't what?
What's charge here?
I'm getting to that, but you understand that there is that offense of criminal sexual conduct in the first degree is a felony. It is punishable by life, mandatory lifetime electronic monitoring, mandatory AIDS or an STD testing. DNA can be taken upon arrest, and the court may impose a consecutive sentence pursuant to statute. Do you understand the maximum penalty, sir? Count 2 alleges that on that same date and at that same location, it alleges the offense of assault with intent to do great bodily harm, less than murder, or by strangulation. That alleges that on that date that you did make an assault upon a Pamela Valdega by strangulation or suffocation pursuant to Michigan or contrary to Michigan statute. Do you understand that, sir?
Sir.
That is a felony punishable by up to 10 years incarceration, $5,000 fine plus court costs. DNA may be taken. Consecutive sentencing may be imposed pursuant to statute. You understand that? Count 3 alleges that on that same date and at that same time that you did make an assault or an assault and battery upon Pamela Valdega, an individual with whom you had a dating relationship contrary to Michigan statutes. That's commonly known as domestic violence. You understand that, sir?
Yes, sir.
Because there is the notion that you had previously been convicted of violating the same statute prior on August 25th, 2003 in the, as I had indicated, the 14B District Court, and by violating it on July 11th, 2019, that would have been in the 14A2 District Court. Upon conviction for the domestic violence, your sentence is enhanced and that becomes a felony. You understand that, sir? That makes it punishable by up to 5 years incarceration, a $5,000 fine plus court costs, and the court could impose consecutive sentencing if the prerequisites of statute are met. You understand that, sir? Do you understand that? Counsel, how does your client wish to plead to those charges?
Stand mute.
Defendant standing mute. Court will enter a not guilty plea. Pre-trial in this matter will be set.
1:30 before Judge Funky.
April 8th, 2025, 1:30 before Judge Conkey.
What is it, sir, again?
April 8th, 2025, 1:30 before Judge Conkey. As to the defendant's bond, the court, after hearing testimony in the case and pursuant to the Michigan court rule, the defendant is charged with the crime of criminal sexual conduct in the first degree. The court does find, after hearing testimony, finding the testimony of the witness being very credible, therefore making it very likely that the defendant will be convicted, or that presumption of his conviction is great. Therefore, the defendant is denying the court will change his bond from the $50,000 bond. Pursuant to that court rule, defendant's bond is denied.
No bond?
You have no bond. Thank you.
Your Honor.
Off my case. Put a jury on my case. Off my case. Guys, I'm sorry, Your Honor.
take yourself out of here without any further noise, Mr. Lee.
Honorable Judge. Not angry, I won't bite. I might, but don't worry about it. Wow.
That really, really sucks. I mean, really, really.
Well, that was terrible. Let's hang out and see if we get the payoff here. Oh, good Lord. Our 14th break. Yeah, yes, indeed, it got worse. That was just excruciating. Meanwhile, it was not a close call. The right thing happened, but it was a 2-inch putt, and we had to sit there and get raked over the coals for it. You knew he was getting bound over. You knew it. I knew it 30 seconds in. There's no way the judge is like, no, I just don't think that happened. Like you said, we're not even to beyond a reasonable doubt at this point. Forget it. He's headed to trial.
Just have a seat in the middle, chair. I'll pull it in. Can't you move to the? That's your motion. Oh, that's your.
I don't know. There's supposed to be a soft sit here, courtesy of Alyssa.
If we could call Mr. Covington's case, please.
Calling case 23005855101, the people of the state of Michigan versus Marion Covington. This matter is scheduled today for competency hearing and motion hearing. Appearances for the record, please.
Good morning, Your Honor. Heather Harwood on behalf of the people, P81100.
Good morning, Your Honor. Wyatt here, 354-891 on behalf of Mary Ann Covington.
And good morning, Your Honor. Danny M. Woodson, P68870, potential standby counsel for Mary Covington.
Mr. Covington, you state your name for the record.
Good morning, Your Honor. My name is Marion Covington.
All right, good morning, sir. Everybody can have a seat. We'll handle the competency first. I've received a report here dated January 15th, 2025. Does everybody stipulate to its admission as court's exhibit number 1?
People stipulate.
Defense stipulates.
All right. Do both counsel stipulate that the report authored by Dr. Jessica Tovlinski, MD, psychiatrist, consulting forensic examiner, diplomat in psychiatry and child and adolescent psychiatry, American Board of Psychiatry and Neurology, finds the defendant competent to stand trial?
People stipulate, Judge.
Defense stipulates, Your Honor.
All right. And I'd like to just put in here, it says opinion and competency to stand trial. It is my opinion that Mr. Covington was competent to stand trial at the time of the evaluation. Following are the data and reasonable detail upon which my opinion is based. Then the very last paragraph of the report indicates, I respectfully acknowledge that the ultimate decision in this matter rests on a judicial determination. At the same time, it is my opinion that aggregate information supports the conclusion Mr. Covington is competent to stand trial. Counsel, do you know if he's being prescribed medication?
He is not, Your Honor.
He is not.
Not to my knowledge. Is that correct, Mr. Mayor? No, he is not.
Okay. Then I am gonna mark that he is competent to stand trial. The case shall continue to the next stage of the criminal process. I'm gonna make that determination. I'm gonna sign the order finding him competent to stand trial. All right, next we'll move on to Mr. Covington has filed a motion to disqualify the judge. Counsel for the defense, do you wish to address this or do you want to have your client address this?
It's Mr. Covington's motion, Your Honor.
All right, Mr. Covington, sir, if you could please stand, can we have you come around here to this microphone so I can hear him, please? Thank you.
He needs a copy of this.
All right, here, I can give it to him. I'm gonna need that back.
Okay, you want to make a copy of it?
No, I've read it. I'm over there.
Okay, go to the podium. We'll leave that up right here.
I don't know if you want this, Marita. All right. All right, Mr. Covington, whenever you're ready, go ahead, sir.
Your Honor, I would respectfully request that you grant my motion to disqualify the judge due to the fact that you have showed prejudice and bias to my case. You have told me that the Constitution, my constitutional rights is not my rights. And I feel like there's a conflict of interest, Your Honor.
Okay, anything else, sir?
I submit.
Okay, well, first of all, I have never, ever told you that you don't have constitutional rights or your rights, so that's inaccurate. Let me finish, sir. I also, the court is gonna find that I am not prejudiced or biased against you. I can, I think that, my rulings have been appropriate. I am not in any way biased against you or prejudiced against you. I believe this is just another attempt by you to stop this trial from going forward. So I'm going to deny your motion to disqualify. All right, now we have an April trial date on this matter, and before you had been asking to represent yourself, I am going to allow you to renew that motion at this point in time because you have quite a bit of time to get ready for the trial. But before we do this, what I'm going to do is I'm going to ask you to go in the back and talk with the two attorneys about this idea of representing yourself. Because I don't think that's a good idea, and I'd like to have them counsel you on that. But the ultimate decision is yours, sir. So we're going to take a little break. I'm going to let you go in the back and talk with them about this. Are you still considering doing that, or you want Mr. Harris to represent you?
Yes, I'm still considered, but you already violated my Sixth Amendment right when you told me I couldn't.
Okay, well, I haven't violated your Sixth Amendment right, but we're gonna let you go in the back and talk with your attorneys about this. This is a big decision, but if you decide to go forward, I'm gonna ask you a number of questions on the record, okay? So we'll take a little break here and we'll let you talk with them and see if you still want to go ahead with this idea. I think it's a very bad idea, but that's up to you. All right, we'll take a break here.
I just leave my stuff here. Judge, can I leave my stuff here?
Can you do what?
I just leave my items here. I don't need.
Yeah, I'm not gonna guarantee that.
Let's say stuff, you just read it. Don't involve this case.
We can bring Mr. Covington on out. He said what? All right, he's not gonna come out?
Yeah.
All right, and let's get in touch with IT and get a hookup so we can talk to them. Call IT and have them hook up a monitor so we can talk with them, okay? I don't know who does
Let me
it,
ask.
but whoever it is, let's get that set up.
Otherwise, we gotta contact the jail and see if we can get in trouble. That's one of those shots. Should have wrestled this guy. I had a little idea it might work.
But you know what, I'm just gonna go ahead and we'll call the case.
Okay.
Let's, Mr. Harris, come on now.
He definitely can hear you.
Huh?
He can hear you.
All right,
The audio is set up. Yeah, it's on Zoom. See this, the class.
He just can't answer and we won't hear anything he says.
Maybe.
yeah,
can you
let's
log
go
in
ahead and
again?
just call the case.
Calling case 23005851101. The people of the state of Michigan versus Marion Covington. This matter is scheduled today for final conference. Appearances for the record, please.
Good good morning, Your Honor. Heather Harwood on behalf of the people, P81100.
Good morning, Your Honor. Wyatt Harris, P54891 on behalf of Marion Covington.
Miss Woodson, if you can unmute, please. All right. So, Mr. Covington is refusing to come out to address the issue of whether he wants standby counsel or not. So at this point, there is no motion for standby counsel. So we are going ahead with Mr. Harris on this matter. I'm gonna keep Ms. Woodson on this just in case he does ever bring it up. But he has no motion in front of the court. So we will see everybody for a jury trial date. What's the date, ma'am? April 14th at 9 o'clock. If he doesn't come and ask for a standby counsel by February 28th, then I am not gonna allow him to have a standby counsel. So if he wants standby counsel, he needs to come forward and bring a motion by February 28th at 9 o'clock. So anything else we need to take up?
Yes, Your Honor.
All right, go ahead.
There is a evidentiary hearing that was conducted prior to my accepting the case. The date is August the 1st of 2024. Mr. Covington would like the transcripts from that evidentiary hearing.
All right, Madam Clerk, can we order that?
What's the date again?
8/1/2024. Mr. McWilliams was his attorney.
Anything else we need to take up?
There is the trial transcript of 12/4/2024 that Mr. Covington also wants. 12/4/2024.
Okay, anything else?
And then last but not least, apparently
12/4, and that's called what?
it's the trial transcript, the jury trial transcript.
Well, we didn't have a jury trial.
We did. We selected the jury and there was an
All
evidentiary
right,
hearing.
well, okay. There wasn't any testimony.
I know, but that started the jury trial. And then last but not least, Your Honor, Mr. Covington would like that laptop that he could have over in the jail to review the discovery. Now, I don't know how this discovery matter works, but I've heard that they do give them laptops. I don't know how they get the discovery.
Yeah, order from the judge.
All right, I'll order that he's allowed to have a laptop. Anything else?
And that would be it, Your Honor.
All right, counsel, if you can go back and let him know if he doesn't bring a motion for representing himself by February 28th, then it's too late.
Will do, Your Honor.
All right,
Thank you.
anything else we need to take up?
Nothing further.
All right, nothing further. This hearing's completed. Everybody have a great day.
Well, there you have it. I did like his preamble on his motion. He told the judge, with all due respect, I'd like you to grant my motion because you're biased and you told me I have no rights. That was fun. All right. I guess we'll hang out.
TRD 819. Ms. McHenry entered no plea to charges of no operator's license and expired plates, each of which is a minor misdemeanor, on December 17th, 2024. I scheduled it for a bench trial for January 8th of 2025. Ms. McHenry was given notice of that bench trial. I have a signed receipt in the file showing she got notice of that bench trial. Present on January 8th, 2025 was the law director along with a police officer. Ms. McHenry failed to appear. As a result of her failure to appear, I issued a warrant for her arrest. That was January 8th. It's now over a month later, February 11th, and Ms. McHenry is now turning herself in on the warrant. She is in the courtroom, and she is without an attorney. Ms. McHenry, why were you not here on January 8th of 2025?
I have a question about the case.
Ms. McHenry, sit down. This is not your courtroom. Sit in that chair.
I have a question about the case. That's not the case number that I had.
Yes, it is, Ms. McHenry. You've got other cases pending that are set for jury trial.
The original case number that I had was like TDR, like 0800 something. And
24 TRD 819.
819, okay. I was just double checking on the case number. Can you repeat your question then? No.
Why were you not here on January 8th?
I put in an appearance and it was rejected and struck from the record, and I was sent a letter saying that I am not who I said I was. So I have a question about that because I don't understand.
This is not a discussion here. This is not a conversation. I ask a question, you respond to my question. Now, this is typical behavior for you because you're a sovereign citizen. At least you claim to be.
I've never claimed that.
Well, your documentation that you filed, including the one you filed today that did not have a correct caption or case number on it, is indicative of that. So let me ask you, Ms. McHenry, again, why were you not physically, personally present in the courtroom on January 8th, 2025 for your trial?
I need the oath and bonds to be put for each person acting as a public official in this case who is acting as a public servant to be put on the record. And I also require the indemnity bond, and I'm going to require the other bonds. I need the accounting. Please, for the record, let it be known that you exited.
I
while
did.
asking.
I exited the courtroom and asked a police
Who
officer,
is-
probation
Who has
officer.
the indemnity bond?
Uh,
Where's the bill of particulars?
The
Because
bond
I
is
did not
being,
receive it.
the warrant is being executed. You're being taken into custody. Take her down to the jail now.
I was not given the warrant.
Take her down to
either.
the jail now.
Why am I being arrested?
Take her down
For
to the
what?
jail.
What crime have I committed? Get off me. This is kidnapping. This is a false arrest. No, this is a false arrest. This is kidnapping. They're violating my rights, my constitutional rights. I put in,
I thought the Constitution didn't apply to you.
the Constitution applies to every living man and woman. You are violating your oath, Mr. Iarochi. What am I being arrested for? What am I being arrested for?
Okay, with respect to the rest of you here today, good morning. My name is Nick Iarochi. I'm the judge, and this is your initial appearance hearing on traffic-related charges that have been filed against you. This is traffic court. I'm going to read all of you your rights, and when I'm done reading you, there should only be 3 of you here, right? Yes. Okay. When I'm done reading you your rights, I will call your case up individually. You'll take a seat in that first blue chair. If you have any questions regarding the rights I'm about to read to you, you can ask them at that time. We'll address the charge or charges filed against you as well.
You said the victim was on scene. Did you have a conversation with him?
I did.
I don't really want to get into what he said, but do you have a name for him?
That was fantastic.
Okay. Fair enough.
Thank you, Alyssa.
Nonetheless, you did have a conversation about what happened. Okay. Did he give you a time period of when his card was used?
The card was used around 3:30-ish.
PM or AM?
PM.
PM. And where was it used at?
The Meyer gas station.
Which is why you were there? Okay. And were there other people at the gas station on hand, like other employees?
There were.
Did you have did you also speak to them about what had happened?
I spoke with 2 separate.
Did you know, is there an ATM inside or on the premises of the gas station?
There is an ATM.
Okay. All right. All right. Did you speak to any of the other attendants? And again, I don't want you to tell me what they told you, but did you speak to any of the other attendants that were there about some kind of credit card issue?
2 separate.
Okay. And did either of them give you a description of the person who is using a credit card?
Both.
Okay. What was that description that you got?
The description was a average, or maybe a little bit taller than average height, thin white male with ginger hair after clarifying.
Okay. When we talk about ginger, what kind of red? Do you remember what kind of red
We got a
we're
ginger.
talking about? Is it strawberry blonde, red, dark red?
Yeah, so I clarified the question, was it strawberry blonde or like dark, like a dyed bright red? And the clerk clarified it was a ginger, maybe a little bit darker.
Okay. All right. Do you have any indication as to where this person who is involved, this person of interest might be?
I did.
Okay, and where was that?
The bottle return area of where, physical store, the actual.
The store, not the gas station. Okay. Is the bottle return located on the outside perimeter of the store? Okay. What do you do with all of the information that you have? I'm sorry, before we get there, what time is it that you arrive at the gas station?
It was right around 4:30. I was dispatched at 4:19 p.m. I arrived at the location right around 4:30.
Okay, and so again, victim is complaining that his credit card is being used at 3:30 p.m.
A little bit after, but yes.
Okay, and it's now 4:30 p.m. When we say delayed, we're talking about all the same day.
Within the same.
Okay, great. Okay, what do you do now that you have all of this information about the credit card and a potential description?
Sure. So with the description and a potential location of the suspect, I then proceeded to the location, which was the bottle return area. The suspect.
Okay, does the bottle return area, are there windows that kind of show the interior of the bottle return?
There are.
Okay, did you look through those windows?
I don't believe I did look inside.
Okay, and again, I want if you just indulge me, what was the description of the person again that you got from the gas station?
Sure, it was an average to slightly taller than average, white male, thin with longer ginger hair.
Okay. When you get to the bottle return area, what do you see, if anything, of interest?
Yes, so when I pulled up to the bottle return area, I pulled up right in front of the windows and activated my patrol car's cruise lights. For clarification, what those do is activate the blue lights on the top of my light bar, so just a steady blue light, not flashing, for officer safety purposes and visibility. And then to exit my patrol car, and I go to walk into the bottle return area, at which point I see the defendant leaving the bottle return area simultaneously as I'm arriving.
Okay, is that somebody who you see in the courtroom today? Okay, could you just point to him and tell us what he's wearing?
Yeah, he's sitting at the defense table wearing a striped purple.
How would you compare his hair as he is in court today to what it was on October 24th?
Hair is certainly.
Or I'm sorry, October 29th.
Yes, sir. Hair is certainly neater in terms of it's not. It seems cleaner and it seems lighter.
Okay, was he wearing any kind of hat or other hood apparatus on that day?
He was wearing the hood was up to his jacket.
Okay, but could you still see his hair? Okay. All right. Did you anticipate to suspect that you would see the suspect on scene?
No.
Okay. When you see him, what do you do?
I said, "Hey, come here for a second."
And what was his response?
The exact response I don't remember, but he continued to push a bike away and try to hop on somebody.
Okay. How are you dressed at this point in time?
And then full class B. Police department.
Okay. You've got logos.
Multiple police insignia, as well as patches. And
And how far are you from the vehicle?
I am maybe 10 feet from the vehicle.
And the vehicle, you said that the blue lights were on, but how is it marked?
Fully marked, to the township police department.
Okay. When you say that you see him push the bike forward, what do you do?
I said, stop, 3 times, at which point the defendant did not stop.
Okay. And so when he didn't stop, what did you do?
I grabbed a hold of him and pulled him off the bicycle.
Okay. Tell us about the rest of that interaction that you have with the defendant at that point in time.
So I pulled him off the bicycle. I tell him stop. Again, I repeat stop 3 times. It was a very quick instance that happened. Again, as you said, I didn't anticipate this to happen. It was very rapidly evolving in a dynamic situation. I grabbed a hold of him. He kind of tenses up. I said, "Hey, put your hands behind your back." I tried to do so. He's tensed up, both arms are like kind of pulled up. I grabbed a hold of his right arm, his wrist, and his bicep. I tried to twist it away from him, put his hands behind his back, which point that did not work. I rated the dispatch that I was fighting with an individual, and I then proceeded to push him up against a wall to kind of pin him there until I could get more officers on scene. The defendant was able to, we'll say, wiggle out of that pin. So what it seemed to me, throwing punches, hands were definitely up near my face. And then we proceeded.
At this point in time, are you physically engaged with him? Are you still
Yes.
grasping his arms?
Yes, we are fully physically fighting at this point. I'm trying to gain control of his body movement and he's trying to flee that. At one point, he does get away from my grip, runs towards the parking lot, at which point his bag gets caught up in his leg, slows him down a little bit. I grab him. We go to the ground and it is kind of a back and forth, up and down, up and down, up and down until I was able to.
Okay, all right, and eventually you were able to make an arrest? Okay, all right. I guess that time while you are going with him back and forth, are you telling him anything? Are you making any verbal commands of him?
I said, stop fighting, to which he responded, "I'm not fighting." That was pretty much it. We got to the ground at one point, I was like, stop.
Give me just a second, I'm sorry.
Next time, make sure that's silenced, otherwise it's mine. Go ahead.
Thank you. I'm sorry. You were kind of describing grasping onto him and going. I'm sorry. You were describing the encounter again.
So back to the verbal commands, I initially said, stop, 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 and then stop fighting. He said he was not fighting. I said, I'm not. I didn't do anything. We continued to fight. When I had him pinned on the ground, I don't remember my exact words, but they were along the lines of stop, stop.
You indicated earlier in your testimony that you had tried to like twist his arms to get him behind his back or something. And you said that didn't work. Why didn't it work?
This arm specifically, I grabbed his right arm. His right arm was kind of like tensed up like this. And he was not allowing the movement to go in his back.
Okay, so it's through the defendant's resistance, physical. Okay. All right. All right. Just to finish it out, did you ever find the credit card on him or any indication that he had a credit card on him?
The credit card was not on.
Okay. And did you eventually run him through lien? Did he have any warrants out for him?
Objection, Judge. I just don't understand the relevance of warrants when we're talking about resist obstruct, that where warrants were not known in any way prior to this officer issuing what were lawful commands.
I'll sustain that
Can I just respond just briefly?
if you must, but it's not going to change my ruling.
I'm anticipating the defense is going to be for an unlawful arrest. And I wanted to get into a framework of inevitable discovery. So I just wanted to lay that groundwork. But I can come back to it if it becomes relevant.
I would say specifically that it becomes not inevitable, right? There is no
I
right.
don't, why am I arguing about this?
That's a great question, Judge.
I know.
I don't have any other questions.
Cross-examination.
Yes, thank you, Your Honor. How you doing today, officer? Pretty well. I'm obviously counsel for Mr. Lay. I'm going to be asking you some questions, but it's not my purpose or intent to confuse you with these questions. So if I ask you something and you don't understand where I'm going or I get too wordy, let me know. I'll rephrase it rather than have confusion enter the record. Sound good? All right. So I believe you stated that it was 1 hour after Mr. Hill had reported that his card, he got notified that his card had been used, that you respond to the Meyer. Is that correct? That you actually make the scene?
Correct.
Okay. Now, is there any knowledge conveyed to you, or do you have knowledge if there's an amount of time that passes between the card being used and the notification alerting somebody that said card has been used?
In this case, I'm not sure, but normally it's instantaneous.
Okay, but in this case, we're not sure. Okay, and we've got at least an hour since that indication was set, so it didn't come after that period of time.
After the alert?
After, yes, it wasn't used after that, to your knowledge. Now, in the course of this investigation, it sounds like you talked to 3 people total? Okay, aside from defendant, and that's two clerks or two attendants, whatever you want to call them, and Mr. Hill. Is that also correct?
That's correct.
And the description that was entered into the record, was a description provided by which of those three?
All three.
All three, including Mr. Hill.
Correct.
Said thin, white man, red hair. And if so, would that be in your report?
My apologies. No. So, would you like me to clarify that?
Yes, I would.
So Mr. Hill described Lay.
I mean, I wasn't, okay, did Mr. Hill provide an independent description?
He did.
Okay. And then go, have you discussed that description already?
I'm sorry, with what?
Did you testify to that description already today?
That Mr. Hill gave?
Yes.
I didn't.
Okay, so feel free.
Okay, so when I arrived on scene, Mr. Hill said that he didn't know who had used the card, but he saw somebody in the area riding a bike suspicious. That described Mr. Lay after I had contact with him. It was not an immediate, that's him, right? There was nothing that he provided me that would have. The description that he gave me at the time he gave me the description did not work towards anything that was credible at that time.
Yes, and in fact, you had he didn't provide any basis for having any knowledge of what the suspect would have looked like at that time. Is that correct?
At that time, yeah.
Okay, so but he did opine without any basis. Is that, he did offer something, it was just a baseless offering. Is that correct?
I would say so.
Okay, and then, so it's the clerks that provide this description, which is the thin, or what do we have here? Average height, thin white male, long ginger hair. Is that comes from the clerks?
Both clerks.
Both clerks. What were their names? Did you take down their names as part of their report? Is this interview captured on body camera?
It is.
Okay. And you stated that they distinguish ginger by its darker, sort of, a darker form of red as opposed to a lighter form?
Yes.
Okay. And you testified about Mr. Lay's appearances that day relative to today.
Sure.
And you said that his hair then was, I believe you said at least darker. I'm not sure if you said more red.
I did not say more.
So just darker, but not red, is how you recall it.
Darker than it is today.
Okay, thank you much. Now, how long do you spend talking to both Mr. Hill and to these clerks in your best guess?
Minutes.
Minutes, less than 10?
Yes.
Okay, and then after speaking with all three of them, then you proceed back to the main building of the Meijer from the gas station. Okay, and the idea is that this card was used at this point, when you arrived back at the main building, more than an hour prior, or attempted to be used. That was the idea, whether it was or was not. Okay. Now, when the clerk identified the individual, and the reason the clerk was providing that identification to you and that it was relevant is that that was the person they had seen using an ATM earlier, right? Did they give you any sort of time frame, the clerk, as to when they witnessed the ATM being used?
No time frame was given.
Okay, so did you presume then that that was the same time frame as indicated by Mr. Hill?
That was the only person that had used the ATM at that time, or excuse me, during that time that employee had been there. So there was only one person to use that ATM.
If it was in fact used.
He said he saw, the witness said he saw somebody use that ATM.
The clerk?
Yes.
Okay, but he did not indicate a time to you specifically.
Correct.
So when it comes to part of connecting Mr. Hill's allegations with the clerk's account, rather than asking the clerk for a time, you presumed that it was the same time that Mr. Hill's card was attempted to be used? You did not independently ask a question regarding that.
I guess I reasonably assumed that with the clerk being right up there front, can see that the ATM, the only person to use that ATM was the person who matched that description. That's what based it on.
Sure, but you never asked him a time. That's my point. Okay, thank you. Now, when it comes to, I think you stated, and I wanted to make sure I didn't get this mixed up. The clerks gave you the description that was used as part of your basis for moving forward with the investigation, but they're not the ones who conveyed to you a potential location for the individual. Is that correct?
That's
Where did you come upon that on your own, or did you get that potential location from somebody else?
That came from Mr.
From Mr. Hill. Now, Mr. Hill, at this point in time, and you acknowledge, had already given you essentially a baseless description of who he thought might be the suspect. Is that a correct way of putting that?
Upon initial contact, it was baseless. After confirming with the clerks, it was not a baseless description. There was merit behind it.
And what was that merit?
The description that the clerks had given matched to the description after the whole thing was said and done. In hindsight, it all matched, right? So the clerks had given a description, the victim, Mr. Hill, had given a description. Upon contact with Mr. Lay, all the descriptions match.
Well, now I'll ask you this, not knowing where, but Mr. Hill was completely unable to provide you with a basis from where he would obtain a description. Is that from where he obtained some description of this individual?
You saw the individual.
Take his card?
No,
You
saw the individual in the area.
So it's what you're saying is that he saw somebody who he thought looked suspicious.
I don't want to put words in his mouth. That could be, I'm not sure.
Okay, well, if he didn't see him take his card and he didn't see him use the card, right? Then, I mean, fill in the blank for, I mean, how is it that he's providing a description of a person whom he has either never seen? I mean, this is where there's a disconnect for me. And he's providing you with a location from where?
You're asking me to speculate about Mr. Hill. So he doesn't have to answer that. If you want to ask another question.
Thank you, Judge. So you go to the bottle return location, and that was after speaking with Mr. Hill. Okay, and you alight from your vehicle, and that's when, and you first see my client. Is he inside or outside at that point?
Outside.
He's already outside. Is he about to get on? I mean, does he look like he's going sort of as you're coming to approach it?
It's a very simultaneous, I pull up, he's thinking.
Okay, and so, and at this point, he is a average height, thin white male with ginger hair. Is that what you're proceeding upon?
Correct.
And there's nothing else?
No, that is simply it.
All right. Now, there's no card discovered. I mean, there was no time after you announced this where my client would have dispensed with property in your presence. Is that correct?
Card was not found.
Card was not found on his person. Now, turns out loss prevention gets involved, and there is not even a person at the ATM in the time period in question. Is that correct?
After the incident was happened, yes, we found that out.
You looked at the videos and saw there was no person at this ATM during the time.
Loss prevention.
Loss prevention, and you got to confirm that.
They advised me, hey, nobody was in this, at the ATM during this time, or we can't capture anybody at that location.
Understood. And Mr. Hill's or the clerk's description, at least Mr. Hill's identification of a location at the bottom return produced the wrong guy. Is that right? No, I mean, it didn't produce the correct guy. This is not the person who's.
So, hindsight, at
Well,
the time of the incident, it wasn't sure, it all happened very quickly, we weren't sure who was, excuse me.
I agree.
At the time, I went to investigate this, I made contact with Mr. Light. Later, after he was taken into custody, we were trying to do our investigation before that, he was taken into custody.
You were trying to do the investigation before you took him into custody because you just wanted to speak with Mr. Lay to confirm some things after talking to the clerks. Is that right?
Sorry?
You just wanted to investigate by speaking with Mr. Lay when you approached him after you had spoke with the clerks.
Correct.
Correct. I have no further questions at this time, Your Honor.
Any redirect?
I just want to make sure that I get this clear. Victim reports his card is used at 3:30-ish at the ATM inside the Meyer gas station.
Correct.
And you make contact, and then they tell you that there's only one person that's used the ATM all day.
Within the time frame that he has seen, yes.
Okay. All right. Okay, that's all.
Nothing further, Your Honor.
You may step down. Thank you.
Thank you for your testimony, officer.
Any additional witnesses
I don't
for
have
the
any
people?
witnesses at this time.
Any witnesses for the defense?
None, Your Honor.
Motion.
Your Honor, at this point in time, I motion to bind the defendant over on the charges contained in the complaint.
Response.
And Your Honor, what we have here is, and I understand, and I think it was motivated from a good place. But what we have here is a suspicion that's not articulable, that is not particularized. We have a white male with red hair. And God forbid that the description had been, thin, an hour prior for use, Your Honor, an hour prior for use of this card. Maybe, if there is not some increased lag between that. And what happens is, and we have the officer admit, he wanted to approach Mr. Lay to further investigate, because that's what was needed at that time. And Mr. Lay didn't want to participate in that investigation, which as a free citizen was his right to do at that point, when what we have is frankly, an admittedly baseless description from Mr. Hill and a report from two clerks who, with no name, that are never named in the report. And a report that ends up being entirely false, that Mr. Lay was never even in the gas station, that loss prevention confirms that nobody used a card up there. Whatever information here was the opposite of reliable. Nothing was confirmed to give basis.
Yeah, but Mr. Hall, that is great in hindsight.
Sure, I understand, Your Honor. I definitely understand as it relates to what's found by loss prevention. And I think the reason it was wrong, and so easily wrong, is that there was so little, and this is the only way I relate it back, Judge. There was so little in the beginning. We have a white guy with long red hair. Now, Mr. Lay has blonde hair. You could argue it's strawberry blonde. It's not dark red by any stretch. But here's what Mr. Lay could be described as. He could be described as a person who a lot of folks, whether law enforcement or otherwise, and he's judged, we've got a lot of, he's been clean for a long time now, but if you look at his mugshot, he's the kind of guy who looks like he could be a drug user. He looks like he could be homeless. He looks like he could be suspicious, not the appropriate, not the above board kind that we can base probable cause on, but the general kind that we all as human beings use, sometimes in an extraordinarily flawed way. And in this case, Your Honor, my argument is that average height, thin white male with long ginger hair, ginger particularly being described as a darker version of red, is not enough to 1 hour after an alleged criminal act come and put hands on this man. And People v. Moreno gives him the right to at least resist an unlawful command. And if at that
But is the
point,
command unlawful?
acting on the command, my argument is acting on the command is unlawful, Judge. You can say stop and no to anybody, whether or not he, if you're saying no, and then you're saying, does that command have the force of law where Mr. Lay, I feel, should be forced to stop, then no, I believe that's an unlawful command. I do not believe the officer's authority based on the description he has at that time is sufficient to force somebody to essentially be detained at that point, working off of thin white male with longer, darker red hair. Would some people look at Mr. Lay and just outright say he looks suspicious? I believe they would. And unfortunately, that and returning cans, I believe had him as potentially an easy target for blanket suspicion, but not reasonable suspicion, Judge. And I'm differentiating those two on purpose because we don't have the quantum of facts here to support probable cause.
Yeah, I think the court was kind of getting there. The crux for me is the issue of the investigative stop. Does the officer have reasonable suspicion at that point in time? The officer made contact with the victim, followed up. He's being told that the victim's card was being used at this ATM. The clerks are saying that they saw somebody using the ATM. They give a description of that individual. He goes to just investigate it. He said, I wasn't expecting to see anybody. I come up and I see a thin white male with red hair. He's got the hood up, but he can still see the red hair poking through the sides. At that point in time, does the defendant have, or does the officer have reasonable suspicion to stop and investigate, to entertain an investigatory stop? That brief, small window between a consensual encounter and an arrest. If he's got reasonable suspicion, he can say, I need you to stop. He can take his identification. He can identify him. He can do those things. But we don't get to that point because he lawfully issues the command stop, and the defendant doesn't. Instead, he tries to ride off. At that point in time, now the situation has changed where he's now not obeying a lawful command, and that's how we get into the rest of the resisting and obstructing that takes place after the fact. And so I do think that there's a basis for him to issue those commands, and I think that the defendant did not abide by those commands that led to the rest of the fight. So I think that the officer's actions were legitimate. I think that the court should find him over on the charges contained.
Judge, talking about this officer prior to encountering Mr. Lay had heard the description from Mr. Hill and had already determined himself that it was baseless, that Mr. Hill was guessing and for no reason known to the officer. And he stated
But
at the time, Judge, which means that the only thing we're working about is these physical attributes. And instead of thin white male with red hair, it could have been thin black male with black hair, Judge, and he could have picked one of 40 people out of that.
So if this involves somebody different, every stop on the south side of Ipsy, you're asking me to throw out.
No, Judge, I'm saying very
You
much.
know exactly what I'm saying.
I do, Judge, but if that's what I think if a stop is based on thin, even on the south side of Ipsy.
That won't work on the south side.
I agree with that.
I'm just saying, there are
It shouldn't work on the
descriptions,
south side or anywhere
it shouldn't
else.
be working anywhere.
It shouldn't work.
But
anywhere.
darn it, it does.
What, the description?
Oh, those description, medium complected, medium height. Yeah,
It
you hear it
should
all the
work.
time. So
If that's it, Judge, in many of those cases, in so many of them, you and I provided, there's something else. There's something related to clothing or an element of the offense or anything.
Go ahead.
Judge, I'll stop.
Anything else?
Nothing, Judge.
Just to correct the record, the description came from the attendant, not from Mr. Hill.
I understand that. I was listening. The officer gets this description.
I was here.
Yes, Mr. Hall, I would agree that certain parts of it are tenuous and may relate factually as to whether or not whether or not the defendant could then, I guess, resist or walk away at that point. What is clear based on the testimony that's before the court is that the officer is investigating something. He is asked for a momentary detention to ascertain something about somebody that may match the description. Now, one can quibble with that, one can go back and forth. But at the time he does that, he's attempting to try to further his investigation. That's when the officer can do what he does to further that investigation. The escalation at that point is because of the actions of the defendant. It then gets escalated more and more. And at some point, what could have been the defendant saying, I'm not answering your questions, could have been the defendant saying, whatever, just give him his name. Maybe not even give him his name, not do anything. This officer's acting in lawful performance of his duties. When he makes the initial inquiry, it becomes the defendant's actions that lead to it. And then ultimately, this court believes, and certainly it may be questions of fact that are really tiny facts as it's going, that may lead to this, but it's not something I can decide at this time. But what I see is there could be a resisting and obstructing at some point during that transaction. So for those reasons, I would find that the people who have indeed sustained their burden, I would find the defendant over to stand trial as judge. I'll admit it's a tenuous one, but I think it needs to go to trial.
Thank you.
All right. As to the arraignment. No, you.
Yeah, we
just talk.
wait for reading and stand mute at this time. I do have an advice of rights executed.
Defendant having waived formal reading, standing mute, court will enter not guilty.
If I may approach, Judge. Whoops. Thank you, Corporal.
Pre-trial in this matter will be set.
August 9th,
April?
April 9th.
April 9, 2025, 1:30. Who's the judge? Judge Conlon. Thank you, folks. Bond continue.
Thank you, Judge.
Thank you, Your Honor.
Just going to need the parties on the Luther Williams matter. Miss Perrine and Miss Burton Harris.
You're all set. Okay. All right. Thank you. Appreciate you. Stay. Oh. Yeah. Yeah.
Mr. Hall, you see Miss Perrine out there? Would you?
Yes, well, Judge.
Thank you.
Oh.
Yeah, too late, but thanks.
They gotta go find Mr. Vincent now, wherever he might be wandering off to.
Yeah, she's running around out there somewhere. But
Ready? Court does call the cases. People State of Michigan versus Luther Williams Jr.
Good afternoon, Your Honor. Victoria Burton Harris, Chief Assistant Prosecutor, appearing on behalf of the people.
Good afternoon, this is Little Feather Ron County on behalf of Mr. Williams. Williams, the statement for the record.
Thank you. We have a seat. Date and time set for preliminary examination. Are we ready to proceed?
Your Honor, the people are ready to proceed, but we do have one preliminary matter before we do so.
All right.
As the court is aware, count 2 and count 3 allege that the defendant, Mr. Williams, was a felon in possession of a firearm and ammunition, which does require a prior felony conviction. Defense counsel and I have discussed Mr. Williams's 2023 release from his 15-year prison sentence after being convicted of felonious assault, assault with intent to do great bodily harm, and assault with intent to rob while armed. And I believe just for exam purposes, defense counsel stipulates to the court taking judicial notice of Mr. Williams's 3 prior felony convictions.
That's correct.
All right, very good.
All right, so with that, Your Honor, we are ready to proceed.
All right, let me call your first witness.
Thank you. The people call Deputy Jacob Gambos to the stand.
Sir, please come forward and be sworn.
Take a seat, raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. State, spell your first and last name for the record, please.
Jacob Gambos, JACOB,
You may inquire.
Thank you. Good afternoon. What do you do for a living? How long have you been employed there? I'd like to direct your attention to October 14th, 2024. Were you working that day? Can you tell me what shift you were working?
8 p.m. to 8 a.m.
Do you remember riding in a patrol car with Deputy Sims at or around 9:45 that night?
I do.
You two were assigned to patrol together for that shift?
Yes.
Were you in a marked patrol car?
Yes.
Were you in uniform?
Yes.
Are you familiar with Luther Williams Jr.?
Not before this case.
How did you become familiar with Mr. Williams?
Dispatch call for service.
Is he in the courtroom today?
Yes.
Can you briefly describe something he's wearing and where he's sitting?
Wearing a collared shirt at the defense table.
Your Honor, please let the record reflect that the witness has made an in-court identification of the defendant.
Record show so reflect without objection.
Thank you. On October 14th, 2024, were you dispatched to 348 Furwood Street in Ypsilanti Township, Michigan, Washtenaw County?
Yes.
Was that part of your shift on October 14th?
Yes.
What was the nature of that dispatch?
We were dispatched for a return trip to the address. The initial call for service to the address was a report of a male, specifically the caller's ex, knocking on the door and threatening her through the door. We initially were unable to locate him or his vehicle. We were dispatched back at approximately 9:45 for him returning and knocking on the door and threatening her again.
When you went back the second time, did you encounter any suspects when you arrived on the scene?
Not on initial arrival, but we did locate a suspect vehicle in the area.
And how did you locate that vehicle? Were you given a description of a suspect and the vehicle they were driving?
Yeah.
When and where did you encounter that suspect vehicle?
In the same neighborhood, it's 2 streets, one of which is a dead end, the other leads, Furwood leads into Elder. Elder is a dead end. We've found the suspect vehicle at Elder and Furwood.
That area where you just described, is that also in Ypsilanti Township, Washtenaw County?
Yes.
Who was driving the suspect vehicle?
I do not recall his name. Remember.
Was it the defendant that you've just pointed out?
No.
What did you do when you encountered the vehicle?
I conducted a U-turn to get behind it to pull it over.
Why did you do that?
It was a suspect in an ongoing stalking investigation we were conducting.
Were there any other reasons?
No.
At any point while you were behind the suspect vehicle, did you at any moment observe an object being discarded or thrown out of a window of the car?
I did.
What did you observe?
I observed the passenger of the vehicle make a slight throwing motion towards the passenger side window. I observed a object matching the size or similar with the size and shape of a firearm coming from that window and landing on the ground near the street.
So I imagine you and the deputy that you were with, you at some point got out of your patrol car?
Yes,
And at some point, Mr. Williams, was he handcuffed and arrested?
yes,
After Mr. Williams was handcuffed, did you search the area where you suspected a gun was thrown?
yes.
What, if anything, did you find?
I located a black and silver 9mm handgun.
The location where you found the gun, was it consistent with where you'd seen Mr. Williams make a throwing motion outside of the passenger side window?
Yes.
Could you observe the gun without manipulating anything?
Yes.
Did you secure the gun?
I'm sorry, what?
Did you secure the gun?
Yes,
Would you recognize the firearm if I showed it to you?
yes,
Was the firearm loaded?
yes.
Your Honor, I'm showing the defense counsel pre-marked People's Exhibit 1, which contains 2 pages, to permission to approach the witness.
Yes.
Deputy, do you recognize People's proposed Exhibit 1?
Yes.
What do you recognize that proposed Exhibit 1 to be?
I observed it to be an overall picture of evidence collected and a close-up of the firearm collected.
Does it also show a photograph of some bullets?
Yes,
And were those bullets recovered from the firearm that you found in the area that you searched?
yes,
Does that photograph appear to have been altered or manipulated in any way?
no,
Your Honor, at this time, we request the admittance of People's Exhibit 1, both pages.
Any objection or voir dire?
No objection.
Exhibit 1 is admitted.
Thank you. Officer Gombos, was an inventory search conducted of the truck after the arrest of Mr. Williams?
Yes.
Was a pistol case or a gun holster found in the truck?
yes.
Where was it found?
On the center console, specifically with the, so to describe.
I'm gonna object for lack of foundation. There's no foundation that he was the one that searched the vehicle or found this item.
I'll sustain it and allow you to ask some follow-up questions.
Did you at any point observe yourself a holster on the center console?
No.
No further questions, Your Honor.
All right, cross-examination.
Good afternoon. So on 10/14, you report to the Firewood Street address. Furwood, thank you. And it was about a domestic between a male and a female.
Stop.
Okay. And there was a report that the man was hitting on the door with an object.
Yes.
And threatening to shoot.
Yes,
And when you arrived, you testified the man was already gone, but possibly still in the area, driving a truck, a white truck. And you take a few turns to the neighborhood as you testified and you located the vehicle. And when you pull behind that vehicle, which you would agree with me that those windows are pretty tinted. And you see the brake lights activate when you pull behind these folks. And the car slows down a little bit. And that's when you see the item being thrown from the vehicle. And it comes out through the passenger side window. And you see it kind of glint in the lights. But you don't see an arm come out of that window. And you don't see like an extension of a hand. You don't see anyone pull that gun from a glove box, for example. You don't see the person pull it from their pocket, for example.
correct.
And when the item is thrown, you kind of see the car jerk back a little bit.
I don't recall that.
You go recover the gun. Yes.
Yes.
And it's submitted to the Michigan State Police lab. And they do tests on that gun to make sure it's functioning correctly, make sure that it wasn't altered in any way, which the results came back that it was not. And they didn't do any fingerprinting on that gun. They didn't do any DNA testing on that gun. And you've been an officer for how long?
5.5 years.
And you've been trained on things like identification,
Correct.
searches.
Correct.
One of those things you've been trained on is Miranda.
Yes.
And how to Mirandize a suspect.
Yes.
As we know, there are 4 statements that a police officer has to advise a suspect.
Yes.
And you speak with Mr. Williams at the scene. Sorry, you have to answer verbally. I know it's a little awkward.
The way that you have your statement.
Yeah,
thinking you're
you
gonna
weren't,
have it.
didn't know if it was a question.
Got it. You speak with Mr. Williams at the scene, correct?
Correct.
And at that point, he's in handcuffs, right?
Yes.
He's in the back of your patrol vehicle.
Yes.
And you're asking him questions about what took place.
Yes.
And you don't tell him that anything he can or he says can and will be used against him.
Correct. I misplaced my Miranda card and tried to go from memory and obviously did not correctly state Miranda warning.
Okay. May I confer with my client, Your Honor?
You may.
No further questions, Your Honor.
All right, any redirect?
No redirect, Your Honor.
All right, you may step down. Thank you, sir.
Thank you, sir.
Call your next witness.
Thank you, Deputy. Your Honor, the people call Deputy Hannah.
Come forward and be sworn.
Solemnly swear upon the testimony about to give you the truth, the whole truth, and nothing but the truth, so help you God.
I do.
See,
First name's Kyle, Kyle, last name's Hannah, Hannah.
You may inquire.
Thank you. Good afternoon.
Hello, how are you?
Good, how are you?
Good, thank you.
Good. What do you do for a living?
Deputy Sheriff for Washington County Sheriff's Office,
How long have you been employed there?
approximately 2 years.
I'd like to direct your attention to October 14th, 2024. Were you working that day?
I was.
Can you tell me what shift you were working?
It was an overtime shift. I got off at 8 PM originally. But I was working overtime from, yeah,
Were you in a marked patrol car?
I was.
Were you in a uniform?
Yes, actually,
Exact same uniform?
probably different shirt, but did close to Class B uniform, yes.
All right, thanks. On October 14th, 2024, were you dispatched to 348 Furwood Street, Ypsilanti Township, Michigan, Washington County at or around 9:45 at night?
So I was not dispatched, other deputies were actually dispatched, and due to how it came across Metro East, I was in the area.
Okay. What was the description of the vehicle that you want to look out for?
Metro East came over and advised that it was a white GMC pickup truck.
And at some point, did you observe the suspect vehicle during your shift?
I did, yes. And to further on that, when deputies got on scene, they advised that it was a Denali. The style or model, whoever you want to put it, was a Denali. Wait,
A white Denali. When and where did you observe the white Denali?
as I was going southbound on Elder Street, I observed LED headlights coming towards me in a slower fashion, which kind of drew my attention. With it being 9:45 at night, dark, I kind of found it interesting. So I posted up at Furwood and Elder Street. I was still on Elder Street. I parked my patrol vehicle so I could observe the vehicle coming towards me with the LED headlights.
And while you were on Elder Street observing this vehicle, was that also in Ypsilanti Township, Washington County?
Correct, yes.
Was the truck moving when you observed it?
I don't recall.
Was the traffic stop effectuated for any reason?
Based on Deputy Gaboson's, yes.
Who was driving the truck?
I believe his name was Isaac Brown.
Was there a passenger in the truck? Who was it?
First name Luther, I don't remember his last name. He was identified by his Michigan identification card.
Okay. Did you have an occasion to effectuate an arrest of Mr. Luther Williams?
I detained him for that time, yes.
Do you see Mr. Williams, who you detained in the courtroom today?
I do.
Can you please point to him and identify him by something he's wearing?
My left side, looks like a blue and white polo with a collar.
Your Honor, please let the record reflect that the witness has made an in-court identification of the defendant.
Record shall so reflect without objection.
Thank you. I have no further questions for this witness.
Cross-examination.
Just briefly, when you effectuated that arrest, you didn't see Mr. Williams with the gun,
No, I did not.
and you didn't see any gun being thrown from any vehicle?
No, I did not.
No further questions.
All right, thank you. You may step down. Thank you.
Thank you, Your Honor.
You may call your next witness if they are available, I think.
Your Honor, at this time, the people would move to bind the defendant over as charged on the counts before the court. Count 1 being weapons carrying concealed. Count 2, weapons, firearms, possession by prohibited person. Count 3, weapons, ammunition, possession by a prohibited person. I believe that based on the testimony of Deputy Gambos and Deputy Hannah, that there is sufficient probable cause to establish that.
Ms. Burton here. Let me just stop you one moment. You've rested.
Yes,
Okay.
I apologize.
No, it's okay. You,
I just realized
Ready to
I
go.
totally
That's all
skipped
right.
over that.
any witnesses for the defense?
No, Your Honor.
All right, you may go ahead now.
I am so sorry, Lord. We still believe that based on the testimony of both Deputy Gambos and Deputy Hannah, that there is sufficient probable cause to establish that these crimes were committed and that Mr. Williams committed them for the matter to be bound over to circuit court. And specifically as it relates to possession of the firearm, because I know that that's going to be the issue. The reasonable inference based on the evidence, including the officer's testimony, is that the defendant possessed the gun and he tossed it out the window. Furthermore, it's reasonable to infer the defendant possessed it while traveling inside the car. He had an opportunity. It was in close proximity. He exercised dominion and control over the firearm when he threw it out of the window. And so for those reasons, the people are asking for this matter to be bound over for trial. Thank you.
We're objecting to bind over. I want to go back to why this vehicle started, right? So there was this driver of this vehicle. There's 911 calls that he's banging on the door with a hard, heavy object and threatening to shoot the place up, right? They get back, assumingly we weren't there, but he gets back in the vehicle, drives away. The car is pulled over. My client is the passenger of that vehicle. Deputy Gambos testified that he saw the gun go out the window, but he didn't see an arm. He didn't see where that gun came from.
Well, except that it came from the vehicle.
Right.
Okay.
He didn't see it be pulled. He just saw that it came from the vehicle. He agreed with me that those windows were very tinted. He couldn't see in through those windows to identify who was there or when that gun was thrown. Just that it came out the window. My client, never made any statements about the gun.
Who's ready for my tent
that were
rant?
Admitted in the testimony. There was a brief mention of a holster, but again, there's no evidence of linking that holster to my client. Really, the only thing that we have before us is that a gun was thrown from a car. Just because my client
On the passenger side.
Just because my client was sitting on that
I
passenger.
mean, that's right, correct.
That's correct, yes.
Okay.
My argument though, Your Honor, is just because my client was sitting on that passenger side doesn't mean it came from him. We can think of 1,000 other reasons how that gun got thrown out that vehicle. And my argument to this court is that the driver could have thrown that gun. There is evidence on the record that he possibly was in possession of the gun moments earlier. I don't think the people have met their burden even on a probable cause standard, Your Honor.
Aren't these issues and questions of fact that I can't resolve?
Yeah, I think there's nothing connecting to my gun. The gun's my client. There's no evidence in the records there.
Anything additional from the people?
Oh, no, Your Honor.
No? Okay, all right. Based upon the testimony we've heard in this case, and it's factually, it's rather simple. The weapon comes from the vehicle that the defendant is riding in. It comes from that side of the vehicle. The issue of possession, factually, that may be an issue of fact as to who possessed it, but certainly the defendant could have, I don't know that it needs to be established at this point, been in possession either joint or otherwise with the individual in the vehicle. I also would find it rather interesting, and if, as defense might assert, there's a possibility that the driver had it and threw it across a vehicle outside window on the passenger side. I gotta miss some things before I even get to that window, and I don't know that that's very plausible. So in looking at this, the court does believe that there is at least sufficient evidence that the defendant should be bound over to stand trial on count one with the stipulation which was placed on the record. The court would bind the defendant over on counts 1, 2, and 3.
I
want to dumb her down to take, like I want to fight that.
And in wait for reading standing mute to the charges, court will enter a not guilty plea as to all 3 counts. Pre-trial in this matter will be set
April 3rd at 1:30 p.m. Judge Slay.
April 3rd, 2025, 1:30, Judge Slay. Bond will continue.
Thank you.
Thank you.
Thank you, Your Honor.
Okay, and Ms. Lundy, you and Mr. McGuire, what I have left, I'm gonna take a break before I begin now.
Does the court know about how long, so I can give my witnesses a chance to maybe take a short time to go grab some food or something?
Oh, people want to eat.
They do, I mean, I want to. I won't speak for
You
that.
know, I hadn't thought about that today, like eating.
I enjoy eating. Oh, thank you.
It was,
Sure.
I had 18 cases.
Yes, sir. I'll tell you what, yeah, let's it's what, 1:44? Can they do it in a half an hour or so? Half an hour, 45 minutes? Why don't we just look at coming back at 2:30?
2:30?
2:30? Will that work? All right, quarter standing recess.
All rise.
Oh, sweet Jesus. Is it Magoo? Is it on? All right. I think I'd close this one down and just start that one fresh. They said Magoo? Okay. I'm going to close this stream down. I don't know what I'm going to do with this mess. Where am I here? You can see I'm really here. I'm going to close this thing down, set up another stream for 2:30, and we'll do that. I don't know what to do with this thing. If it wasn't for the first hearing, I'd just leave it. I don't know. We'll figure it out. That's not your problem. It's mine. All right. I will see y'all soon.